Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for The Law of Self-Defense, and we are here today to talk more Alec Baldwin trial news. Alec Baldwin, of course, is the actor who shot and killed cinematographer Halyna Hutchins on the movie set of low-budget Western Rust. With the single-action revolver he held in his hand, he pointed that gun directly at Halyna Hutchins. He manipulated the gun, certainly cocked the hammer, apparently pressed the trigger, did not ensure there was no live rounds in the gun. In fact, there was a live round. It discharged. It penetrated Halyna Hutchins under her right armpit, traversed her body, broke her spine, mortally wounded her. She would die on the floor of that church pew on the movie set. Shortly thereafter, the bullet would pass completely through her body and bury itself in director Joel Souza, who would survive the bullet wound. Armorer Hannah Gutierrez was tried for involuntary manslaughter for failing to ensure there was no live ammo on the movie set. She was convicted and recently sentenced to 18 months in prison, the maximum sentence for involuntary manslaughter under New Mexico law. Next month, it is Alec Baldwin's turn to stand trial. Jury selection is July 9th. The trial proper starts July 10th. And Alec Baldwin, unlike Hannah Gutierrez, has brought on board a very costly, prestigious legal defense, oddly consisting mostly of civil litigation attorneys out of Manhattan law firm Emanuel Quinn, one of the top 50 law firms in the world. Several partners working on this legal defense, 6 or 7 other junior partners or associates, and 1 local New Mexico counsel, as is required by the rules. So all these other Manhattan attorneys can argue before the court. And all the legal argument that I've seen to date for the Alec Baldwin defense team has been not by local counsel, but by the pro-hack vici counsel brought in from outside of New Mexico. And they've been very aggressive, filing lots of motions, making lots of arguments, many of them seemingly preposterous on their face, but nevertheless they're made. And the state prosecutor, Carrie Morrissey, has to respond. Recently, the defense had argued that the grand jury indictment against their client, Alec Baldwin, should be dismissed on a variety of specious grounds, including that the grand jury was not presented with defense evidence by the prosecution, that the prosecution had given the grand jury an improper jury instruction on involuntary manslaughter. This was argued in motions, written documents before the judge, and argued orally before the judge, who then issued her ruling denying the defense motion to dismiss the grand jury indictment for an alleged failure to state a criminal charge. But the defense is not giving up. They have another reason why they think the grand jury indictment should be dismissed, this time with prejudice, meaning that if it is dismissed, Alec Baldwin could not again be indicted on this shooting of Halyna Hutchins. This time they're saying that the prosecution destroyed evidence. Destroyed evidence. Sounds pretty bad, right? Destroyed evidence. I expect this to be swatted down by the trial judge as well, but these are the motions being argued now before the court. Yesterday, we covered some argument being made before the court on a couple of fronts, one of which was the argument that certain defense witnesses that the defense had listed on their witness list and then later withdrew when during pretrial interviews those witnesses gave responses unfortunate for the defense client Alec Baldwin. The defense doesn't want them to appear as witnesses at trial after all. And of course, the state very much does want them to appear. So we have this witness dispute. And also the question of whether Hannah Gutierrez ought to be granted use immunity so that she can testify at the trial and be subject to cross-examination by the state. The defense does not want Hannah Gutierrez to testify under immunity. So yesterday we covered the state argument for why Gutierrez should be granted immunity and compelled to testify in the Alec Baldwin trial. When I did yesterday's show, I had not yet seen a response from the defense arguing why Hannah Gutierrez should not be given immunity. That response appeared in the record today. Now, it was filed by the defense last Friday, but of course, yesterday was Monday, and when I looked at the court website, that response was not up yet. It is up today. So while I had planned to focus on this destroyed gun evidence issue, in the interest of completeness, I think I'll start today's show with the defense objection, counter argument to the Hannah Gutierrez immunity issue. They do not want Hannah Gutierrez to be granted immunity. It's a short motion. It's only about 7 pages long. And then I'll cross-link the first part of today's show with yesterday's show, just for purposes of completeness. All right, folks. So with that out of the way, let's go ahead and start the formal launch of today's show. Here we go. And of course, we must mention our sponsor, which is none other than CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members legal expenses if the member is involved in a use of force event, and they do much else as well. I think the world of these guys. I do quite a bit of partnering with CCW Safe. I personally choose CCW Safe. I'm a member there myself. My wife, Emily, is a member. There are other companies offering similar services out there in the marketplace. Some of them are worth considering. Some of them may be a better fit for you than CCW Safe. All our circumstances are different. Certainly, CCW Safe is the best fit for me, perhaps for you. So I would encourage you to check out what's available on the marketplace. I would caution that some of the offerings on the marketplace are dumpster fires, hot garbage, that I could not in good faith recommend to anybody. So make an informed decision. I've made the decision to be a member of CCW Safe, and perhaps they're the best fit for you too. You can learn why I trust CCW Safe at lawofselfdefense.com/trust. I have a little video there where I explain exactly why I feel they're the best fit for me and for my family. Perhaps you'll decide the same as well. And if you go to that URL, lawofselfdefense.com/trust, you'll also receive a 10% discount code you can use for your own CCW Safe membership. lawofselfdefense.com/trust. All right. So, as I noted, let's start first with the defense response to the state's request motion. A motion is just a request to a court for the court to do something. The state had made a motion to the court to grant Hannah Gutierrez, the recently convicted of involuntary manslaughter armorer on the set of Rust, to grant her use immunity so she can be compelled to testify and be subject to cross-examination in the trial of Alec Baldwin. Yesterday at some length, we covered that motion by the state asking for immunity. Today, we have this motion filed last Friday, but just put up on the court website today from the defense objecting to this request. So what does the defense have to say? Most of this is pretty rich stuff and not very compelling argument. So based on that, of course, I expect we'll have oral argument on this as well. Based on, I think the oral argument is scheduled for the 21st of this month. So we'll certainly be live streaming that. I don't see many compelling arguments here from the perspective of Alec Baldwin, the defendant, on why immunity should not be granted. Now, there may well be reasons that Hannah Gutierrez doesn't want immunity, doesn't want to lose her ability to assert her Fifth Amendment right not to testify. But of course, she's not filing this response. So what does the defense have to say? Defendant Alec Baldwin hereby opposes the state's notice for use immunity for Hannah Gutierrez. Preliminary statement: the state's late filed motion for use immunity to secure live testimony from Hannah Gutierrez Reed should be denied. So right away, the defense is focusing on a purported late filing, late notice. They're trying to suggest they were ambushed by the state's request that Hannah Gutierrez would be granted immunity and compelled to testify. Um, this is a silly argument for the defense because, in fact, the defense has had Hannah Gutierrez on their own witness list for months. So the defense was well aware that Hannah Gutierrez could appear as a witness. They chose her as a witness on their witness list, and so advised the state. So she's certainly been on their radar. She's not an ambush witness to the defense, so the late notice hardly applies here. Doesn't really make any sense. What I'm sure the defense is really objecting to is they only wanted the testimony of Hannah Gutierrez that was favorable to their client to make it before the Alec Baldwin jury. What they're trying to do is get that half, the favorable half of the Gutierrez testimony in front of the jury, and avoid having Hannah Gutierrez subject to cross-examination. Avoid the jury getting all the Gutierrez testimony. Continuing with this objection, the testimony the state purports to seek is contained in Gutierrez's prior statements the state has had for years. If the state felt it needed a grant of use immunity in this manner, it should have filed this motion when it first learned Gutierrez intended to assert her Fifth Amendment privilege. The state did not do so, and all parties continued to prepare for trial on the understanding that Gutierrez would be unavailable at trial. Is that what all the parties thought? Because the defense had her on their witness list. Do you put someone on your witness list if you believe she's going to be unavailable at trial? And when they say unavailable, they don't mean physically unavailable. They mean that if she was called, she would assert her Fifth Amendment right not to testify. The late edition of Gutierrez, by the way, they call her Gutierrez Reed. This is Gutierrez. That's not her name. Her name is Hannah Gutierrez. She just chose to attach Reed to her name. Reed is the name of her nominal father, not her biological father. It turns out her mother, who was married to Fel Reed, a famous armorer in Hollywood, her mother apparently stepped out on Fel Reed while he was on a movie set someplace, got knocked up by some other dude, bore Hannah. Hannah Gutierrez's legal name is Hannah Gutierrez. She's not biologically related to Fel Reed. And Fel Reed has known this his whole life and raised Hannah as his daughter, but her legal name is Hannah Gutierrez. Reed is just an artificial addition to associate her with the really pristine armorer reputation of her nominal father, Fel Reed. The late addition of Gutierrez Reed to the state's witness list to provide open-ended, unspecified testimony at this late date is unjustified and prejudicial. The motion should be denied. Well, that's what you would expect the defense to say. Because Hannah, as we saw yesterday, Hannah would be expected to testify if questioned by the state on a variety of things harmful to Alec Baldwin. He was inattentive during his safety training. He didn't show up to other safety training that he agreed to show up to, and so forth. That some actors on the set were double checking to make sure their guns weren't loaded, something Alec Baldwin didn't do. This is all testimony the defense does not want in front of the jury. Background. Under the court's February 26 scheduling order, the parties were directed to make their respective discovery disclosures within the time frames set forth by the rules. Now, this is the defense saying, well, this is an ambush witness. We didn't know there was a possibility that Hannah Gutierrez could be called as a witness, which is a ridiculous argument because Hannah Gutierrez was on their own witness list. Now, they're going to argue here that Hannah Gutierrez was not listed on the state's witness list, and somehow that makes her an ambush witness. That's a silly argument, too, on another level, because the state, when it listed its witnesses, also had a catch-all at the bottom of its own list saying, and we incorporate every witness listed by the defense. So by incorporation, Hannah Gutierrez was on the state witness list and has been for months. So this is a silly argument. This is smoke and mirrors, sleight of hand, legal mumbo jumbo. But this is the defense argument. The state had filed an initial witness list on February 6th, listing 30 witnesses. It followed this with an amended witness list on April 3rd and April 19th, disclosing new witnesses. The state then filed an addendum to its third amended witness list on April 25th, adding yet another witness, and a further addendum on May 6th, the deadline set by the court to add new witnesses, adding another 8 witnesses. So this is all normal, folks. It's normal that as the state's developing its case, developing its arguments, trial is approaching within the window of time permitted by the court, meaning by May 6th, you're free to add witnesses. That's completely permissible. Nothing wrong with this. That same day, May 6th, the state filed a motion to exclude defense witnesses disclosed for the first time on May 6th, the deadline for adding witnesses, arguing that the state is prejudiced by the defendant's improper tactic aimed at sandbagging the state. So what happened on May 6th, the last day to add witnesses, is the defense team had added a whole bunch of witnesses. And the state, obviously on the deadline. So to preserve the state, to preserve its ability to contest these witnesses, rather than, they didn't have time to do like in-depth interviews of each one, they were notified on the deadline, the last day. So they filed peremptory exclusions, motion to exclude. Now, they don't necessarily need to exclude those witnesses, but they're saying we're reserving the right to exclude if we decide we have a legal basis for doing so. And the sentiment by the state is, hey, the defense knew about these witnesses for weeks or months. They filed them on the last day for a reason, to ambush us. The defense continues. None of the states' timely filed witness list included Hannah Gutierrez-Reed. So this is lying by omission, as I already explained. Hannah Gutierrez-Reed was not named specifically in the state witness list, but the state witness list said, and we include in our own witness list, by incorporation, every defense witness in the defense witness list, where Hannah Gutierrez-Reed, Hannah Gutierrez, was listed. So Hannah Gutierrez is on the state list by incorporation. She need not be specifically named. So when the defense says none of the state's witness list included Hannah Gutierrez, well, that's true. She wasn't included by name, but she was included by incorporation. So this is lying by omission to the court. The defense continues. Of course, the state has known about Gutierrez since well before its first witness list was filed. Gutierrez was tried and convicted for the same incident by the same prosecutors in February and March, and has a pending appeal. Defendant's first amended witness list, filed on April 19th, did include Gutierrez. So the defense is admitting we had Gutierrez on our witness list. Well, if we look at the state's motion, the state makes this point as well. This is the motion we covered yesterday. This is the state's request for immunity. They note Gutierrez is listed on defendant Baldwin's witness list and on the state's witness list by proxy, by incorporation, as the state has reserved the right to call all witnesses named by the defendant. So really a specious argument here by the defense. Continuing, let's see. The state requested a pretrial interview for Gutierrez-Reed, which was held on May 19th. Well before that date, the state was advised by counsel for Gutierrez that she would assert her Fifth Amendment privilege, and the state proceeded to confirm that position in the interview. They asked Gutierrez a few preliminary questions, things like, what's your name? How are you feeling today? About her employment on the set of Rust, and then she answered those, but then she asserted her Fifth Amendment privilege against self-incrimination for the remainder of the interview, as is her right, for sure. The state did not indicate it would seek use immunity or otherwise attempt to circumvent that assertion of privilege at the time of this interview. Well, they're not required to do that. On May 30th, the state provided the defense with more than 350 recordings of calls purportedly made by Gutierrez from prison. These are the calls that got Gutierrez in trouble with the judge at sentencing. That's why the judge, well, that's probably why the judge tagged her, classified her as a violent offender that has to serve 85% of her 18-month sentence. Otherwise, had she not been so flagged, she would only have had to serve 50% of her 18-month sentence. The many of the calls from prison, from jail, were very derogatory to the court, to the judge. Um, Gutierrez clearly assumed no fault at all for what happened. She was simply being persecuted, blah, 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 blah. So the state provided the defense with more than 350 recordings of calls purportedly made by Gutierrez from prison. Actually, I would expect from jail. The state has provided no further content or explanation of the relevance of those calls. Well, this is just part of discovery. The state intends to use some of those recordings at trial, obviously, especially if they want to use them to impeach Gutierrez if she's testifying. So they're meeting their discovery obligations by providing those recordings to the defense. They don't have to tell the defense what their strategy is for the use of that evidence. They simply are obliged to make the defense aware of the evidence, provide them with access to the evidence, which is what they did here by providing the recordings. On June 3rd, the state filed a purported third addendum to the state's third amended witness list. Why would that be purported? Purported is like when someone claims they did something, and you're like, well, there's a purported claim. We don't believe the claim. There's reason to doubt the claim. But why would there be no reason? Why would there be reason to doubt that the state filed an amended witness list? I mean, it's in the court filings or it's not. That's weird. But the state filed a purported addendum to their witness list disclosing, without providing explanation, 3 witnesses not included on any of the state's 5 previous witness lists. Well, were they on the defense witness list and incorporated by proxy, like Hannah Gutierrez? One of these witnesses was Gutierrez. The state then, for the first time, and 2 days before the pretrial interview deadline, presented the request for the court to grant use immunity to Gutierrez. We just covered that. That was on June 5th, was that immunity request to the court by the state. Argument: the state's belated request that the court grant use immunity for Gutierrez testimony at trial and order her to testify at trial, as well as its untimely addition of Gutierrez to its 6th witness list, comes months after Gutierrez was disclosed on defendant's witness list, weeks after Gutierrez' entirely non-substantive pretrial interview was completed, well after the deadline for adding witnesses, and just weeks before the trial is set to begin. Well, some of this just doesn't matter, right? So it doesn't matter that it was after the deadline for adding witnesses, because Hannah Gutierrez was, as the defense concedes in its first point here, that disclosed on the defendant's witness list, which was incorporated by proxy. Just because something is happening just weeks before trial is set to begin doesn't mean it gets excluded from the trial. There can be no good cause for the state's untimely request. The state has known about Gutierrez's involvement in this case since 2021, has known that she was on the defendant's witness list since mid-April, has known that she intended to assert her Fourth Amendment privilege since early May, which is only a month ago, folks. If the state wished to secure live and unfettered testimony from Gutierrez despite her ongoing appeal of her criminal conviction, something the state has known about since March, it should have made this request well in advance to allow all parties a fair opportunity to explore Gutierrez-Reed's testimony. Well, we still have a month before the trial. There's still time to question Gutierrez. Everybody's aware of what she has to say. The defense has also known about Gutierrez-Reed and her relevance to Alec Baldwin's legal jeopardy since the event in 2021. They know she was tried. They know she's testified. They know about the prison recordings. They certainly have not been ambushed. They just would much prefer that Hannah Gutierrez not be subject to cross-examination in Baldwin's trial. The defense continues. The state's request is not only untimely, is it though, but also prejudicial. Now, keep in mind, folks, everything opposing counsel submits as evidence is presumably prejudicial to your own case. That's why it's being offered by opposing counsel, because it helps them and it hurts you. So the mere fact that evidence is prejudicial doesn't mean it's excluded. Everything offered by the other side is prejudicial. Alec Baldwin's own police interview, his interrogation, the day of the shooting, is prejudicial to Alec Baldwin. You think that's coming into evidence? It sure is. The parties have concluded the pretrial interview process and are fully engaged in preparing for trial. Well, isn't all this part of preparing for trial? Including preparing for the state's 44 timely disclosed witnesses. This is rich because the prosecution is really 2 attorneys, maybe 3. The defense has something like 8 or 10 or 12 attorneys. So to argue that, oh my gosh, Your Honor, we're having so much trouble preparing for the state's 44 witnesses, the vast majority of which the defense has known about for years, it comes across as rather specious. Moreover, days before it filed this request, the state disclosed hundreds of Gutierrez-Reed's prior statements for the first time. These are the prison recordings. By the way, the defense could have had those at any time. They knew that they existed because they were referenced in Gutierrez sentencing. So again, this is not ambush evidence for the defense. The defendant understood from Gutierrez's interview process that she would not, in fact, be available for trial and has been preparing accordingly, with no indication that the state had anything else in mind. So they know she exists. They know immunity is a thing. Allowing the state use immunity at this late juncture to introduce a previously unavailable witness with hundreds of previously undisclosed statements, the prison recordings, after the deadline for witness disclosures has passed, without time to conduct proper pretrial interviews, and just weeks before a complex trial, would prejudice defendants' due process rights. Let's see. Indeed, it is hard to imagine how the state could claim that this belated disclosure and request is not prejudicial when it previously asserted that it was prejudiced by the defendant's timely witness disclosures, characterizing those disclosures as a calculated game of sandbagging, as less than 30 days remain for conducting pretrial witness interviews, and the defense as choosing to lie in wait and ambush the state because the state would not have an adequate opportunity to conduct interviews and investigate the witnesses with an entire month remaining of the pretrial interview period. Well, of course, this is comparing apples and oranges. So what the defense had done was on the last day added a bunch of witnesses to their witness list that had never been previously disclosed to the state, that the state had never been aware of, were not on the state's radar, could not have been on the state's radar. And the state objected, saying, hey, we reserve the right to exclude these witnesses because we may not have time to interview and investigate these people. We never heard of these people before. And there's a bunch of them. That's a completely different scenario than the state saying, hey, you know what? We may want to cross-examine Halyna Hutchins, who everybody knows about, who has tons of prior statements, both in police interrogations prior to her own trial, the prison recordings. Everybody had Halyna Hutchins on their radar. These are not similar situations. Here, a continuance is not required or sought because the state has not made any specific showing as to why Gutierrez's live testimony at trial is necessary. Well, they have, actually. They made clear that Halyna Hutchins would testify about Baldwin was inattentive during his safety training, failed to show up for other safety training, could have checked the gun for live ammo. Other actors on the set were doing that. The state offers no explanation as to how it contends that the defendant's opposition to this motion is a clear indicator that the defendant intends that only exculpatory testimony from Ms. Gutierrez be presented to the jury. The parties have anticipated, since at least May 19th, that Gutierrez-Reed would be unavailable to testify. But her testimony will be in the trial because it's in recordings. It's just that the defense believes that the recordings are more favorable to them than harmful. What they don't want is they don't want a live Halyna Hutchins to be subject to cross-examination by the state. The state has offered no justification for why, at this late stage, it is necessary for the court to grant its request for use immunity. Well, that'll be for the court to decide, won't it? For that reason, the court should deny the state's request for immunity. So that's it for the Halyna Hutchins immunity issue. That's the defense objections. Not very compelling argument. All right. Let's see. Now we're going to get into the destruction of evidence arguments. Let me see quickly if there are. There we go. Oh, I see in the comments that a very different case. Hunter Biden was guilty on all 3 counts. Interesting. Interesting. Maybe I'll talk about that in a different show. Probably not. Maybe I'll be a guest on someone else's show. I see Steve Gosney's in the chat. Steve, if you want to do a show on Hunter Biden, maybe I'll join you. Hey, Steve, if you want to join for this discussion on the pistol, the destruction of evidence issue, let me know. I'll send you a link. Steve's insight would be very interesting here. Okay, so that is, yeah, I think everything else in the chat can wait. By the way, we only address questions from and comments from Law of Self-Defense members in the member chat, not on YouTube, not Rumble, not on Twitter. So if, although we are currently streaming on all of those platforms, when we get to the Q&A period of today's show, as is our practice, we will end the YouTube, X, and Rumble streams and continue with only the Law of Self-Defense members and do the Q&A portion of the show. The good news is you can be a Law of Self-Defense member for just 99 cents, folks. Get a trial membership, 2-week trial membership for 99 cents. Get all your questions and comments answered for free as a Law of Self-Defense member. And if you stay a member after the 2 weeks, and virtually everybody does, it's still dirt cheap. It's only about 30 cents a day. 30 cents a day. Less than $10 a month to be a Law of Self-Defense member. But at least try it out for 99 cents at lawofselfdefense.com/trial. And you'll be immediately emailed instructions for how to join us on the member stream, the member chat, and participate in the Q&A for this show. And as long as you stay a member, every show that we do. That's at lawofselfdefense.com/trial. All right. So now, just like with the immunity issue, yesterday I had the state's request for immunity, and I did not have the defense objection to immunity, which is what we just covered. Obviously, there's a delay in these things. The one party makes a request to the court, the other party needs time to respond to that request. Today, we're going to cover the defense request to dismiss the grand jury indictment on the grounds that the state destroyed evidence, destroyed the revolver involved in this event. I don't have the state's response to this, but when the state makes their response, presumably within the next few days, I'll cover that as well in a different show. Let's see. I'll just, you know what? I'll just send Steve a link. And if he can join me, he'll join me. And if he can't, I certainly understand. I'll send it to you as a Twitter DM, Steve. There you go. All right, so let's take a look at this. So just as some context, because I haven't read this yet, so I'm not sure how the defense will characterize it. There's no question that it was the revolver, the single action Western revolver, as illustrated here, that shot and killed Halyna Hutchins, and it was in the hand of Alec Baldwin when it discharged. There's no question that Alec Baldwin knew it was a real gun. He said so during his police interrogation the day of the shooting. There's no question that it was pointed directly at Halyna Hutchins. The bullet directly struck her. There's no question, of course, that it discharged and fired the fatal bullet while it was in his hand. It was not dropped. It was not struck by some foreign object. There's evidence to suggest that he cocked the hammer and pressed the trigger. That's a key part of this because it was tested at the FBI laboratory. And one of the first tests they did was that test. Can I get the hammer to drop without depressing the trigger? And the answer was no. Now, as a further part of the test, an impact test was done, and sometimes called a mallet test. So there's a soft mallet, often a rawhide mallet, that's used to strike the revolver from different angles, from the sides, the top, the bottom, the front, and the back, and on the hammer of the gun, to see if the gun could be made to fire from a blow without the trigger being depressed. Now, that's not actually relevant to the facts of this case. No one is claiming that there was a blow to the revolver, and that's what might have made it discharge. But it's a common part of a firearms examination after a shooting event because the parties want to be prepared. The state, the prosecution wants to be prepared, and the firearms examiner knows this for a possible argument that the gun just went off. So a mallet test is a standard test that's done. And when the mallet test was done on this gun, one of the tests they did was to fully cock the hammer and then strike the hammer with the mallet with increasing force to see if the hammer could be made to drop. What happened as a result ultimately was the hammer was struck with enough force to break internal parts of the hammer. So the way the hammer works is we have the exterior part of the hammer that you would cock with your thumb. We can see that here. Inside the gun, the other end of the hammer has, you can think of it as kind of a stick. Well, it's more of a circle with little notches cut into it. And then the trigger, and we can see the trigger here, the part of the trigger you press with your finger, there's a top half of that trigger. It's kind of like a stick, and it fits into the grooves in the circular part of the hammer. The hammer's resting on that stick. When you press the trigger, the stick is removed from the slot, and that frees the hammer to fall forward. What happened here was the hammer was cocked. The top portion of the trigger was in the appropriate slot, the full cock slot of the interior part of the hammer. The hammer was hit hard enough to break that connection, to break the point of contact. So the tip of the trigger was broken off, and the lip of the hammer notch was deformed as a result. That's the destruction we're talking about. So it's not like the revolver was thrown into a furnace and melted down. The revolver was damaged in the course of testing. Now, again, prior to the mallet test, the gun was evaluated to see if the hammer could be dropped absent the blow, and there was no blow in the facts of this case, absent the blow without the trigger being pressed. So the examiner would cock the hammer into different positions and see what happened. And it was impossible for the hammer to drop from a full cock without the trigger being depressed. So we know this already prior to the mallet test. That's a problem for the defense because the defense is trying to argue that it was not anything Alec Baldwin did that made the gun discharge. It was a defect in the gun because the gun had, they allege, had previously been modified in a manner that made it more dangerous, more likely to unintentionally discharge. Now, how much does this actually help the defense in terms of the theory of recklessness that underlies this criminal charge of involuntary manslaughter? Not very much, because there was more than one thing that Alec Baldwin did that constitutes recklessness. Recklessness meaning the creation, the knowing creation and disregard of a unjustified risk of death to others. Alec Baldwin did more than cock the gun and press the trigger. We have reason to believe he did that, but he did more. And the more he did is material to the death of Halyna Hutchins. For example, we know that Alec Baldwin pointed the gun directly at Halyna Hutchins because that's where the bullet went. We know that the Screen Actors Guild safety guidelines explicitly say never point a gun at another person. So that alone is recklessness. That alone creates an unjustified risk of death. And Alec Baldwin knew this risk because he'd been trained for decades in these safety guidelines. Not checking the gun for ammo, I would argue, also qualifies as reckless. You think if Alec Baldwin if the script had called for him to point the muzzle of that revolver at his own head, you think he would have made sure there was no live ammo in the gun? I do. So the notion that Alec Baldwin didn't touch the trigger, the gun somehow went off by itself, I don't think solves the recklessness problem. Certainly does not warrant dismissing this indictment, even without prejudice, much less with prejudice, because there's other facts in the case that would qualify as reckless conduct here. But nevertheless, this is one of the arguments the defense is making. Let's see. So here we go. Essentially, defense motion to dismiss the indictment with prejudice, meaning that if it's dismissed, he cannot be reindicted. So he would never be tried based on the state's destruction of evidence. Now, the state does have a duty to not destroy evidence, right? If they collect a piece of evidence, especially exculpatory to the defense, and they literally destroy it, they throw it in a furnace, well, that would be a denial of due process, right? Is that what happened here? So, let's see. Preliminary statement. There is no dispute that the state knowingly destroyed the most important piece of evidence in the case without taking even the most basic steps to document its original condition. Well, that's not really true. So, what's the condition? In terms of function, this revolver was tested for proper function before the mallet test broke the trigger and hammer connection. What the defense is trying to suggest is that, well, the state, and by the state here they mean the FBI firearms examiner, did not first completely dismantle the gun and inspect every part of the gun for some kind of damage. Now, by the way, if the FBI examiner had done that and then put the gun back together and then tested it, the defense would be arguing, well, he changed it. When he dismantled it and reassembled it, he changed it. It was no longer in the same configuration as it was in the hands of Alec Baldwin, and they would be complaining about that. Defendant Alec Baldwin, meaning his legal team, now has no ability to examine or test the gun in its original state to disprove the government's theory that he pulled the trigger on the day of the accident. In trying to explain how that conduct comports with basic notions of due process and fair play, the state does not dispute almost any of the key facts that defendant Alec Baldwin repeatedly told investigators that he had not pulled the trigger and the gun just went off, that Detective Hancock of the Santa Fe Sheriff's Office ordered testing for the express purpose of disproving Baldwin's exculpatory statements. Well, that would be normal, right? In other words, she sent the gun to be tested to see, well, is it possible that it could have just went off without the trigger being pulled? That the sheriff's office knew ahead of time that the FBI testing would destroy the firearm. Well, I don't think anybody knew that. Even the FBI tester was like, oops. So there was no intentional destruction. The striking with the mallet, of course, was intentional. It wasn't an accidental striking with the mallet. But that the outcome would be the destruction of those mechanical connections, the trigger sear to the hammer, that was not intentional. So that's a silly claim to make. That neither prosecutors nor law enforcement agents made any effort to document the firearm's internal components before destroying it, or even notify Baldwin about their plans, and that whether the firearm could discharge without the pull of a trigger is central to the state's theory of guilt. Well, I don't know what central means. It's not required. There's other evidence of recklessness independent of the trigger pull, as I already discussed. At the same time, the government selectively omits critical but equally indisputable facts. New revelations by the state's expert. The state's brief their arguments on this issue ignores a stunning concession. The defense loves this histrionic language. Everything is stunning and shocking. Ignores a stunning concession by its own expert, a concession that the defense learned about only recently during the expert's interview. As Baldwin's opening brief explains, the firearm shows telltale signs of pre-existing modifications, such as smoothing and tool marks on the hammer and sear. Although the state has implausibly attributed those alterations to the FBI testing without any support, the state's own expert has now rejected that claim. As the defense learned for the first time in the May 21st interview of one of the state's firearms experts, Michael Haig, last year the state performed a supplemental examination of the trigger and sear, critical components of the firearm designed to prevent it from misfiring. The purpose of that supplemental examination was to identify the origin of certain unexplained tool marks present on the working surface and sides of the evidence trigger/sear. A previously undisclosed August 23 report, which the state did not disclose to defense counsel until Haig revealed its existence in the interview, concludes that the source of those diagonal tool marks of an unknown origin remain just that, unknown. Critically, the report admits that it is unlikely that these tool marks are the result of the damage incurred during the FBI's impact testing, and that they do not appear to be, original manufacturing marks or use and abuse tool marks based on their irregular orientation. So here's the problem with the defense argument here. It may sound compelling, right? It may sound compelling. Oh my God, it looks like there's indications that the gun was previously modified in a way that cannot be explained away innocently. But here's the problem. This is simply a factual dispute, right? The defense is presenting its view of the evidence, its view of the interview, its view of these marks. But the state will have a very different view. And where there's a dispute in factual evidence, that's the role of the finder of fact. That's the role of the jury. So the appropriate way to address these issues is not to summarily dismiss the grand jury indictment with prejudice. It's for this witness to be called by one party or the other and subject to cross-examination. And each side will get its view of these facts in front of the jury, and the jury gets to decide which version of the facts it decides is the more credible. It decides is the actual, not merely evidence, but proof in this case. What establishes guilt beyond a reasonable doubt or fails to establish guilt beyond a reasonable doubt. All of this stuff is stuff that is appropriately argued in front of the jury, which means it goes to trial and gets admitted as evidence. This is the state's expert. Well, the state's expert gets subject to cross-examination. And his statements in this interview, pretrial interview, would be part of that, can be used to impeach him if he says things different during cross-examination than he did in this interview. The defense continues, these admissions leave the state with no colorable argument that its knowing destruction of the firearm satisfied due process. Again, there was no knowing destruction of the firearm. The state did not tell the FBI. The FBI firearms examiner did not say, you know what, I'm going to destroy this hammer and seal with this mallet test. That's not what happened. It is clear. So they say knowing rather than intentional. You see the sleight of hand there? It is clear that the internal components of the firearm designed to prevent accidental discharges had likely been modified before the accident. I think the state would dispute that, right? But because of the state's needless destruction of the firearm, the defense can never examine and test the gun to determine whether those modifications corroborate Baldwin's statements that he did not pull the trigger. That sentence there is what would be argued to the jury by the defense. Next section, experts' admissions about the testing. The state's own experts have admitted that the FBI testing, basically hitting the gun with a mallet, not basically, that's exactly what it was inappropriate, unnecessary, and untethered to the circumstances of the case. Well, that's true. There was no evidence in this case that the gun was struck by some object or dropped, which is what the mallet test is really testing for. But the mallet test is just part of a laundry list of tests that the firearms examiner does. Was that particular one unnecessary in the facts of this case? Yeah, but the FBI examiner probably didn't know the facts of this case. He's given a gun and he's told, all right, do test sequence beta. And the mallet test was part of that. The FBI failed to conduct tests that would have made sense here, such as the push-off test. I actually don't know what that is. Indeed, Detective Hancock and the sheriff's office did not provide the FBI with details about the facts and circumstances of the case that might have informed the FBI's testing decisions. So, in theory, the sheriff's office could have said, listen, you don't need to do the mallet test because there's no fact evidence of a strike, a blow to the gun here. Okay, so nor is it clear that the FBI preserved every piece of the broken gun in its testing. Lucian Haig, that's the father of Michael Haig. So Lucian Haig was the state's firearms expert in the first trial, in the Halyna Hutchins trial. His son, Michael, I guess, has been brought into his firearms expert consulting practice, and Michael is expected to be the firearms expert witness in the Alec Baldwin trial. I don't know if that's for reasons of Lucian's age or he simply wants to give his son an opportunity to get this kind of exposure, whatever. Lucian Haig, the father, noted that it appeared a piece of the hammer had been shaved off, but no fragment of that critical component had been included when the FBI returned the firearm. It is impossible to know whether that loss is attributable to the FBI or the sheriff's office. What is certain, however, is that the firearm was returned in an incomplete state on top of having been destroyed in unnecessary testing. Well, again, it wasn't destroyed in the sense we normally think of as destroyed, right? Normally, we think of destroyed as complete destruction, as if the gun had been thrown in a furnace and melted down. That's not what happened. A part was broken during testing. Next section, experts' lack of knowledge. The state's arguments obscure that neither its own experts nor the FBI examiner knows the condition of the firearm on October 21st, 2021, when the shooting occurred, and they have each admitted as much. And presumably they would on the witness stand, right? They took no pictures of the internal components and failed to video record the FBI's testing because prosecutors and state investigators never asked for those basic steps to preserve this critical evidence. In short, the state's actions have ensured that no witness can testify about the firearm's original condition. No, but the jury can make reasonable inferences, right? If the gun's taken from the scene, put in an evidence box, and it's not removed from that box until it gets to the FBI lab, we can make a reasonable inference that the gun is in the same condition. Detective Hancock's knowledge of Baldwin's statements. Detective Alexandria Hooters Hancock, the lead investigator in the case, knew that Baldwin had claimed that the firearm went off and that he did not pull the trigger. Yeah, that's why she sent it for testing, to see if that was possible. The state cannot truthfully maintain that investigators never knew Baldwin was claiming the firearm had malfunctioned. I don't think the state's claiming that. Moreover, Detective Hancock also knew that other people on the movie set had told investigators in the immediate aftermath of the accident that the gun just went off. So this is rich. So what the defense is referring to here is, well, there were other witnesses, right? There was other people in the pew or outside the church where the shooting happened who could hear the gun. And they said, oh my God, the gun just went off. as if that is an indication of some mechanical malfunction of the gun. The gun just went off in their perception because they were not anticipating a gunshot. That doesn't mean Alec Baldwin didn't cock the hammer and press the trigger. More sleight of hand, more smoke and mirrors from this defense. Timeline and purpose of testing. The state also ignores that the FBI conducted the testing 6 months after the accident, and that Detective Hancock requested the testing to disprove Baldwin's statement that he had not pulled the trigger. Well, Baldwin makes the statement he did not pull the trigger. It's natural to want to evaluate the gun to see if that happens. The 6 month doesn't matter. This was years ago now, well before this trial. The exculpatory value of the firearm was not only obvious, it was acknowledged by the state's key witness who set out to investigate it, Investigator Hancock, which she did. She investigated it by sending it to the FBI lab to see, hey, is it possible for this hammer to fall and discharge a round without the trigger being pressed? No notice. The state fails to address that Detective Hancock, once informed that the proposed testing she sought could destroy the firearm, not would, but could, authorized the testing without providing any notice to Baldwin or others identified at the time as persons of interest. So they make this notification that the evidence could be destroyed as if this is unusual. Hey, normally this wouldn't be an issue, but in this particular case, we have an unusual risk that the evidence could be destroyed. This is just a normal waiver that everybody who sends evidence to the FBI lab would have to sign, because the FBI lab doesn't want to be lots of testing is effectively destructive testing, or things could go wrong. What if the barrel of the gun had been defective and it blew up when a round was fired through it? The FBI doesn't want to be held responsible for that. So they say, listen, we just want you to know it's possible when we test this that damage could occur. And look who we have here, polo shirt and everything. So casual, Steve.
I tell you, life is good.
So you're out of the public defender's office and you're waiting to start at the prosecutor's office. Is that right?
Well, the 20th is officially my last day, but I have so much vacation to burn because they only reimbursed me for 120 hours. So I'm burning a lot of my vacation time. But officially, my last day at the public defender's is June 20th. My first day at the state attorney's office in Miami is the 26th.
All right. So for those who don't know, Steve is moving on to the next wonderful stage of his life, transitioning from the public defender's office in Florida to the Miami-Dade. Is that what they call it? Miami-Dade County Prosecutors?
Miami-Dade State Attorney's Office, correct.
State Attorney's Office. All right. Yeah. That'll be great. I'm very pleased for Steve. I think this is going to be a great deal of fun for him.
Well, and thank you. You gave me, we had a nice little talk when I was making my decision, and you gave me good guidance and good wisdom, cold, calculating, logical thoughts. But that's what you need. You need a sober analysis of what you're doing, and you provided that baseboard, and that's hard to find in this world. So thank you for the good guidance.
Well, you're very kind, Steve. So before I proceed, your thoughts on this so far?
Well, it's interesting because we covered this issue on something called spoliation in our American law courses, criminal law class and criminal procedure class. So the issue here, theoretically at least, is spoliation. So you have a it's not spoliation, but people remember it that way because it's like you spoiled the evidence. So the concept, of course, is that some evidence that's in the custody and complete control of the state is then destroyed, damaged, or made so that the defense cannot recheck it. And it's a legitimate issue in a lot of cases, right? Sometimes if you have such minute amounts of drugs, for example, and then they test it and it destroys the drugs and there's nothing left. And then they say, well, we did find cocaine, but then the defense can't double check it. So there are due process issues here. However, as we
and of course, testing is often destructive, right? So when you test a drug, whatever portion of it you're testing is effectively destroyed. When you test a sample for DNA, whatever portion of the sample you're testing is destroyed in that process. So it's not unusual for the testing method to end up with the destruction of the piece that you're testing.
Right. Now, a lot of this has to do with intent of the state, what the cause was for the, let's just use this example as a gun that is then destroyed in the process. Well, is it recorded? What is the purpose of the test? Was there a legitimate purpose for the test? Was the defense notified? Was it fully recorded in all ways so that it could be second checked by a defense expert? Were the pieces retained or were they destroyed? There's a big notice issue. So all of those things. And then, of course, assume that there is
that's my fire station. Can you hear the sirens?
I thought it was a train. I was like, okay. So yeah, if you assume that let's assume that the state had intentionally done this maliciously in order to destroy evidence to conceal it from the defense. Okay, that's the worst case scenario. And that's what all defense attorneys fear and project immediately into what happens. The remedy isn't necessarily dropping the case. There can be other remedies that stand short of that. And in our American law courses we went through, there can be jury instructions, there can be presumptions, there can be exclusion of evidence. There's a lot of things. And I don't necessarily think that the gun is even necessary for this prosecution as a piece of evidence. So let's assume they exclude the actual gun as evidence. It just isn't there. But I mean, it's all on video, right? And there's admissions, and there's what is the defense? So I'm just thinking it out hypothetically for your law. So,
yeah, I mean, the shooting's not caught on video, but of course, I mean, Alec Baldwin describing what happened is on video during his interrogation.
Was on video.
No, nope. They were not, the cameras were not rolling when the shot was discharged. They have video of him rehearsing his draw from the holster moments before the shot was fired.
Okay.
But not during and in those, by the way, his fingers on the trigger, clearly on the trigger.
It was a bad trigger discipline.
But the shooting itself was not recorded. But what was recorded was Alec Baldwin's police interrogation, and he describes what happens. I mean, the gun's in his hand. He says he never pulled the trigger. When the gun's sent to the FBI, the first thing they do is test that, right? They fully cock the hammer, and then they release the hammer without pressing the trigger to see if the hammer will drop and fire around, and it does not drop. So the functional testing of the gun was done well before the gun was, the defense says knowingly, but unintentionally destroyed, broken with this mallet test.
Well, obviously, why were they that's the question I have. I'm sorry, I just got done with lunch. So why were they malleting this gun?
I'm not sure I've heard a specific explanation, but my expectation would be that the FBI has a protocol for testing guns that go in, and a mallet test is a common protocol, because a common defense for shootings is, well, it wasn't intentional. The gun just went off. And so it's a very common test to do this mallet test where you cock the gun and then you strike it with a mallet from different angles, especially in cases where someone might claim, well, the gun was knocked from my hand and hit the ground, and that's when it went off. Or you could imagine a scenario here where on a movie set, a big bracket with a light on it fell over and struck the gun in Baldwin's hand, right? Something unforeseeable by Baldwin. Then we could argue that this shooting was actually an accident, right? But as it happens, on the facts of this case, there was no blow to the gun. It was not dropped. I don't think the firearms examiner knew that. I don't think he knew the facts of the case. I think he was just sent the revolver and told, hey, do testing protocol alpha, beta 236 or whatever the standard is. And part of that process, that protocol, just happens to include the mallet test.
Now, this is the FBI testing lab, right?
Right, correct.
So there's some insulation between the state attorney's office and the state and the federal crime lab. So that will provide some protection to the state. Now, I will say that this is smart of the defense to raise this issue, because you may gain some trial advantage through an instruction. They'll be able to make inferences to say, well, gee, the defense would love to have tested that. We have this theory, but we don't have the gun. And why is that? Because of the state. And you might be able to get some kind of instruction or something. So that this is a smart move by the defense. I doubt that the case will be dismissed over this. But it
dismissed with prejudice.
Yeah, well, you've asked for that, of course.
Right.
From a defense standpoint, you're really looking for some sort of presumption to give you an advantage when you present your defense to a jury.
All right. So I'm very pleased to have your insight, Steve. In full disclosure, this is, as you can see at the top here, this is a 25-page motion, and we're on page 8. So I don't know how much free time you have. You're welcome to stay as long as you like.
With lunch. So I love this issue. I've worked on it from a civil context and a criminal context on both sides of the state and the defense. So it's always interesting to see spoliation issues, because it's rather uncommon. And most defense lawyers are not even aware of it, nor state attorneys, nor judges. It's an issue that requires, it's one of those articles I want to write. And I've done a lot of motion practice as a support role in the public defender's office on these type of issues. So I'm always interested. So I'll hang out if you don't mind.
No, of course, you're more than welcome. By the way, it's worth mentioning that I don't recall this issue coming up at all during the Halyna Hutchins trial. Right. So her lawyer didn't follow up on this. This is one of the benefits you get when you have 10 or 12 defense lawyers working in your team, and plenty of time and resources to investigate every potential defense argument you might possibly want to make, which is helpful when there's only two prosecutors on the other side of the table.
Right. And it's interesting. Usually the state outfunds and outmatches because they have unlimited resources, but there becomes a point at which those tables turn and the state is outmatched. And so it's interesting to see it when the shoe's on the other foot. So let's see what they've come up with. This is smart. This is a smart defense. I don't blame them. And I think it's a wise tactic. They won't, I doubt they will get any kind of dismissal with prejudice, but we shall see. It's possible.
Yeah, and it's worth noting here that when this defense team, when they make an argument, even when to my ear it might sound legally specious, like much of this does, if the state half-asses their response, the defense immediately comes back and says, well, they didn't make a very robust argument. They failed to address this issue. That means they waived that issue and we win. So the state is being compelled to expend resources to respond even to these specious arguments. And they're not all specious. But
no,
some
I
of
just
them
read
are
the no notice, and this is what I just talked about, that you should have told us that you were going to do this destructive thing. And like I said, the state probably wasn't even aware of it. And that's what they're going to come in. They're going to be like, oh, we are so busy and we don't know what's going on. But it's the state is also trying to put somebody away for a long time. So why weren't you aware? Why weren't you careful? Right? I mean, whose fault is that? It's not the defense fault. It's the state's fault. So there's a good argument here.
And so I think the argument would be, well, it was not intentionally destroyed. We didn't know the gun would be broken. This is a standard part of testing. It rarely, if ever, results in the breakage of parts in the gun. Just happened this time, unintentionally, knowingly in the sense that we knowingly struck it with a mallet, but unintentionally in the sense that we were not trying to break anything on the gun. I was going to make another point too, but of course now I've forgotten what it was. Oh, and of course, Hancock. So Hancock, the detective, probably doesn't even know what the testing protocol is. I mean, we saw her at trial, not the very best amongst us, perhaps intellectually wise. But she may not have even known that a mallet test was going to be done. And the FBI guy, when he's doing the mallet test, it's not his intent to break anything. Now, do they notify whoever's sending them evidence that, hey, just as a general disclaimer, it's possible this evidence could be consumed or destroyed or damaged in the course of testing. So in that sense, I'm sure Detective Hancock was quote unquote notified on a 3-page release form of fine print that she didn't even read. But that doesn't mean the destruction was the intended outcome of the testing or even the anticipated outcome of the testing. So continuing here. So no notice. In short, if this case, by the way, all of this, of course, can be argued to the jury, right? So the resolution, as Steve has pointed out, doesn't need to be dismissal of the indictment. There can be special instructions given to the jury, special presumptions created.
And even without the special presumptions, let's assume it all gets denied. You're still going to want to argue this because you're going to say, as a defense attorney, you're going to say, here's my scenario that fits this facts, right? The state has the burden of proof beyond the exclusion of every reasonable doubt.
Right.
And they had control of this gun. And our theory, we would love to show you that our theory is possible, but the state destroyed the weapon. Why did they do that? It's not our fault. They've got the burden, and yet this theory of innocence exists.
Right.
So therefore you must find our client not guilty. And that's a good argument.
Yeah, I think it's perfectly appropriate at trial. I'm not sure it justifies dismissing the indictment with prejudice.
Like I said, doubtful, but you ask for that, and then it goes, I see the remedies are listed in descending order of what we want.
Right. Okay, so in short, if this case does not meet the standard of a due process violation for the destruction of evidence, then no case will. The defense loves their histrionic language, I have to say. The state knowingly ordered destructive testing on the most critical piece of evidence in the case without making any effort to document its internal condition so that the defense would have access to that information. The testing method was not relevant to the circumstances of this case, and the state failed to conduct more appropriate tests that can now never be performed. The indictment should therefore be dismissed with prejudice. At minimum, the court should instruct the jury that Baldwin did not pull the trigger and prohibit the state from introducing evidence or argument suggesting that he did. To the extent the court believes any factual disputes are relevant to resolving this issue, it should hold an evidentiary hearing. Now, on what basis would the court instruct a jury that, hey, I'm the judge and I'm telling you, jury, Baldwin did not pull the trigger? The judge doesn't know that.
Well, but that is a factual presumption. Now, again, they're asking for it. That's an aggressive ask. I think there's other instructions that could be done, but it doesn't hurt to ask.
Right. You don't know until you ask, right?
Right.
All right, argument here. The state's intentional destruction of the firearm without documenting its original condition violated Baldwin's federal due process rights for two distinct reasons. So this is the clever verbiage this defense likes. What's the subject of the word intentional here? Because I don't believe they intentionally destroyed the gun. I think intentional is supposed to be describing, well, the destruction happened without them documenting its original condition.
Is that true though? I'd be surprised if that's true. If it was sent to the crime lab and they did not document its original condition.
No, they did, but not in the way the defense wants. So
Okay,
what the defense wanted was the gun to be completely dismantled prior to any other testing and every component to be carefully examined under a microscope and documented. And then I guess you could reassemble the gun and do the normal testing you would do. Of course, if the FBI lab had
modifying the evidence, because
yes,
it's
of course,
not the
then
original
the
condition.
defense would be arguing, well, when they disassembled it and reassembled it, they changed it.
Right.
That's not the same gun anymore. And that's not part of the normal FBI. Now, if this is in a trial before the jury, this issue could be raised, and then the medical examiner would say, well, the reason the state could ask their own expert, the medical examiner, the firearms examiner, sorry. Well, why didn't you first dismantle the gun and document every small part? And he'd say, well, if we do that, we're changing the gun from its original condition. So I don't think there's anything wrong with the defense making this argument, but I think it's exactly the kind of argument that should be subject to factual contestation in front of a jury.
Well, or have a factual hearing and find out if there were procedures in place, were they followed, was it documented, what was done, is this the way that things are normally handled? I mean, was there notice to the defense? I mean, all these things are questions, but so I don't think an evidentiary hearing and the remedy, of course, I don't know. I think that the judge, this is probably, it depends on your judge, but I would guess that this would probably be denied, but the judge would say, but you're free to argue all this to the jury.
Right.
Yeah. And I'm reading down, I'm sorry, I read fast.
Sure. So first, the government violates due process if it destroys evidence that possesses an exculpatory value that was apparent.
Exculpatory value. Is this of exculpatory value, though? See, that's the threshold question.
Right. And you always have to be careful with these little quotes, right? Because necessarily they're absent context, right? They're not citing the complete decision they're citing here. They're just citing the portion that they feel is favorable to them. That's why this is all an adversarial process, folks. Second, the government violates due process if it, in bad faith, destroys evidence that is potentially useful, even if the evidence
do we have bad faith? Do
Right.
we have bad faith? And that's a very hard thing for a defense attorney to prove. How does a defense attorney prove that the state had bad faith? That is almost impossible. Now, with enough investigative resources and trying to do that, you depose who? The cops, the state attorney. It's kind of a ridiculous standard. As a defense attorney, I always hated that kind of burden, because you can't prove bad faith on the side. Oh, we were in good faith. We meant no harm, right?
Yeah, absent a confession, I think the most you could hope for was to demonstrate that there was no good faith explanation for this, right? So the exculpatory evidence is a videotape, and they take the videotape and throw it in a fire. Well, what's a good faith explanation for doing that? There can't be one. Here, of course, there is a good faith explanation. Well, it's part of our normal protocol of testing of firearms. The state's intentional destruction of the firearm also violates New Mexico law, because either the original state of the firearm was material and its destruction caused prejudice, or because the state acted intentionally or in breach of legal duty. For each of these separate reasons, this prosecution should be dismissed with prejudice. All right. State fails to show that this prosecution comports with due process. They make this general statement a lot, the defense. The state violated the Trumpetta standard. Trumpetta, presumably a New Mexico Supreme Court decision. This court need not probe the government's intent and bad faith to resolve the due process question presented here. Under the objective Trumpetta standard, the government's destruction of the firearm without first documenting its internal condition violated due process. The firearm was apparently exculpatory. The whole point of the FBI testing was to try to dispel its exculpatory value, and the state's failure to document its internal condition leaves the defense with no comparable evidence to rebut the state's theory that Baldwin must have pulled the trigger. So lots of stuff subject to contestation here, right? So first of all, the gun was, its condition was documented, right? The lab got the gun. They're looking at the gun. They're writing in their report, in their notes, what it looks like, what the caliber is. Then they do physical manipulation of the gun. They cocked the hammer. They tested the quarter cock notch, the half cock notch, the full cock notch. They cocked the hammer all the way. They release the hammer. They see it. This is all documenting its condition and the function of the external facets of the hammer and the trigger reflect the internal condition of the parts. If it works properly, the internal parts are working properly. So it's not, they didn't disassemble the gun and put the pieces under a microscope. But you can make a reasonable inferences that the internal half of the hammer and the internal half of the trigger were functioning properly if the external half of them was functioning. It's like a pair of scissors. If the handles are swiveling, it's reasonable to infer the blades are swiveling, even if you can't see the blades. So lots of sleight of hand here. Someone informed me in the comments that I was pronouncing the word slight incorrectly. The state's narrow understanding of the apparently exculpatory standard would mean that a defendant could never prevail. As Baldwin's motion explains, the firearm has exculpatory value that was readily apparent to law enforcement agents before they destroyed it. The centerpiece of the state's allegation is that Baldwin pulled the trigger, and the state knew that Baldwin had repeatedly denied that he had done so, saying that the gun just went off. Again, I think, folks, that there's a lot of factual support for a finding of recklessness, even absent the pulling of the trigger. For example, we know that Baldwin pointed what he knew to be a real gun without ensuring it was unloaded at Halyna Hutchins. That we know that because the bullet that the gun fired struck her. It did not ricochet off another surface. It did not magically curve and strike her. And pointing a real gun at another person, absent justification, is reckless conduct. So even absent the pulling of the trigger, I would argue that even if the gun had some kind of malfunction that made it discharge, the SAG guidelines say you never point a gun at another person. The actors I personally know, like Adam Baldwin, tell me he's handled guns in most of the movies he's done. He's never pointed a real gun at another person. You always point a few inches to the side of the person. The camera can't notice, the audience can't notice, but that way, even if the gun discharges horrifically, the bullet misses and it doesn't strike anybody and kill them.
Yeah, and I would say that the defense theory that says disprove Baldwin's statement that he did not pull the trigger, I think that is an unreasonable theory. So just looking at it from a jury question, he was holding a gun and it magically went off without pulling the trigger, I think is rather absurd. Now, have you ever heard of such a thing, like a gun sitting in the corner and it just firing randomly without a trigger pull? And like you say, and then the surrounding circumstances, in order for that, there's a lot of steps that have to occur before the non-trigger pull event that results in causation of death occurs. So I just think it's a rather ridiculous thing to have to disprove. You can say that's an unreasonable theory of defense. What is your thought on that?
I mean, theoretically, it would say the gun was handed to Alec Baldwin with the sear of the trigger broken off already. So it can't engage the hammer. So every time you cock the hammer, it just falls forward. That could be possible. So he may have believed, hey, when I'm cocking the hammer, the sear is going to catch the hammer. The gun won't discharge because I'll be sure not to touch the trigger. right? That could be what he's thinking. Except we know that's not the case here, because we know he was cocking the hammer and pulling the trigger immediately prior to the shooting. The gun never left his hand. So we know the gun was functioning properly then. And we know the gun was functioning properly when it got to the FBI lab, because they did the same test. So factually, that cannot have been the case here. Would that be a hypothetical explanation in a different case where he's handed the gun, he cocks the hammer, he believes the sear is going to catch the hammer, but unknown to him, the sear is broken and the hammer drops? I think he's still on the hook for recklessness, because he's still pointing the gun at another human being.
Yeah, and this is an argument that's targeting non-gun users. So if I was the state, I would look for a jury that has gun knowledge.
Well, I'm not sure they can control that, but they'll bring in their own gun experts.
Yeah, well, but you can screen. I mean, that's what am I looking for in my jury? If you remember your interview with Rosemary Peoples, is that she was looking for people on that jury that were gun owners or gun owner adjacent. And
Right.
that I think, you focus in on what do you think is the critical, because anybody who knows firearms is going to know that these are problems. If you have no knowledge of firearms or the way they work or anything, you could fall for it. It's like, oh yeah, that thing, it's pointing a gun, it just goes off. It's just killing everybody.
I mean, that's true. If you look at people who live in particularly gun control states like New York or New Jersey or Maryland, so they're not routinely exposed to firearms. They see a gun, it looks like a rattlesnake to them. They believe the phrase gun violence, for example, like guns are committing acts of violence. They just spontaneously self-animate and go out and shoot people. Let's see. Whether the firearm was capable of discharge without a pull of the trigger was therefore the critical exculpatory question in this case. I would argue not. And indeed, the state does not dispute that its entire purpose of testing the firearm was to figure out how to disprove Baldwin's statement that he did not pull the trigger. I don't know what the problem with that is supposed to be. It's also clear that the state had strong and obvious reasons to believe the firearm might be defective. Several witnesses said that it just went off, and the gun had telltale signs of modifications or defects. Well, I don't believe that's true or was known to the state. But this notion that witnesses, like, just within hearing of the gunshot, that they describe the gun as just going off as if they have knowledge of how the gun was being manipulated is ridiculous. They were not, of course, anticipating an actual gunshot on a movie set. That's why they're describing it as it went off. In fact, the state knew by the time it authorized testing that other accidental discharges had occurred on set, and that some witnesses had reported that the firearms had hair triggers. Well, whatever a hair trigger is, certainly this gun would have a light trigger, but you still have to press the trigger. Hair trigger doesn't mean it goes off by itself. And the other accidental discharges on set doesn't mean those people were not pressing the trigger. Indeed, they were. But as the state's experts themselves have admitted, the FBI's testing was inappropriate, unnecessary, and untethered to the circumstances of the case. Well, that's true. The mallet test was unnecessary here. What that changes materially for the criminal charge, I don't see. The state has failed to provide a justification for the type of aggressive, destructive testing performed given the firearm's obvious exculpatory value, because there isn't one. In response, the state argues that the pre-destruction state of the firearm is indeterminate, and because Baldwin cannot produce objective evidence regarding the actual signs of modification and alteration on the day of the accident, he has no due process claim. This makes no sense. The reason Baldwin cannot establish the pre-testing state of the firearm is because the state destroyed it. The state's argument is thus a blueprint for the government to destroy critical evidence with impunity. Under the state's view, the only defendants who could succeed on the legal standard, apparently exculpatory evidence, would be those who have objective evidence of the exculpatory value of the object that the government destroyed. But those defendants would then always fail the second prong of the legal standard because they would have comparable evidence. Well, I don't fully understand what's happening here, folks, because I concede I have not read Trombetta. That is not the law. The legal rule is that where a defendant or others inform the government that evidence is exculpatory, the government is on notice of its exculpatory value and must take steps to preserve it, at a minimum through documentation before destruction. So I think when the FBI fire examiner is on the stand under direct by the state would say, well, did you document this weapon? And he's going to say, yeah, here's my report. I documented all kinds of stuff about it. He just didn't do it the way the defense is saying they would have preferred. Here, both Baldwin and other witnesses said the gun just went off, and Baldwin was adamant that he had not pulled the trigger.
Yeah,
Okay.
Self-serving statement, and they don't have, like you said, they don't have any knowledge of that. It's a surprise. He didn't intend it. He's not like, I'm going to kill you. Instead, he was surprised by the discharge, which is consistent with state theory. There's no problem there. And then if you're a bystander, you're not expecting the shot either. So it's all not a problem there.
Yeah, someone in the comments makes a good point. Imagine if they shipped the gun to the FBI for testing and it never arrived. It gets lost in shipment. So the gun's physically unavailable, even at the trial. Does that mean you can't prove Alec Baldwin guilty of involuntary manslaughter? We still have sufficient evidence for that.
Right.
That clearly alerted the state that it needed to preserve the evidence, at least by documenting the firearm's internal condition before running destructive tests. The state cannot escape that obligation by saying that as a result of the very testing in question, Baldwin cannot prove with certainty the original state of the firearm. I don't think Baldwin needs to prove with certainty anything. I'm not sure why the defense, a lot of this defense team, most of it are civil litigators. And a lot of times I feel like they're falling into the civil litigation mold, like they have a burden.
Yeah, that's a big problem in defense attorneys. You see that in defense attorneys, because they get really wrapped up in their defense arguments. Like this is a good argument, I will say, for the defense, but sometimes they take a good argument a little too far, and they get so wrapped up in believing what they're saying and seeing the end, because you project into the state all these ulterior motives in bad, and obviously there's a lot of bad prosecutors out there, so it's not unjustified. But it sometimes comes out like you're sticking your neck out, and you gotta, the burden of proof is the best thing a defense attorney has, and you need to hold on to that before all else.
Continuing, the state also makes the strange argument that it was free to destroy the firearm because Baldwin did not explicitly tell law enforcement that the internal components of the gun were modified or altered. Well, I can imagine the state saying, hey, we had no reason to look for modification because there was no indication of modification. No one told us there might have been a modification. Well, we were not on notice.
Is the gun, is it just in pieces now? Is that the thing now? Or is it still like, here's a collection of parts? Or was it just like something's dislodged? Or is it just like, did they break it and then just throw it in the trash?
I don't know. They displayed a gun during the Halyna Hutchins trial, but I think at least some of what I saw displayed was a copy of the gun, not the actual gun used. And I have seen photos of the internal components, photographed, showing the damage, the breakage. So at some point it was certainly disassembled. I don't know if it was then reassembled. In fact, I think it was reassembled at one point with with undamaged parts, replacement parts, and shown to function normally. But I don't know what the current state of the gun is. But Baldwin is not a firearms expert. He said he was. He's an actor. And he said the gun went off without his having pulled the trigger. That unmistakably conveyed that the gun was defective. Well, you can just take his word for it.
He's an actor. I believe all actors.
Equally strange is the state's contention that the defense cannot show the file marks or smooth parts would serve as direct evidence that Baldwin did not pull the trigger. Of course, a defect in the trigger mechanism of the firearm is not direct evidence like eyewitness testimony, but it is powerful evidence of innocence, which you can present to the jury. The parts of the gun that show signs of modification, the hammer and the sear, are precisely the parts that prevent the gun from going off without the trigger being pulled. If those defects existed at the moment of the accident. So, folks, you have to keep in mind, the defense loves using the word accident, but accident's a legal term of art. So if something is genuine, accident's a legal defense, like self-defense is a legal defense. If something was genuinely an accident, there is no legal liability. Of course, there's the colloquial use of accident, meaning merely something that was unintentional. But there's lots of unintentional things that are crimes if they were reckless. like this. If those defects existed at the moment of the accident, they would powerfully corroborate the assertion that Baldwin did not pull the trigger, seriously undermining the state's theory of the case. That's all trial argument to my ear. Notably, the state has acknowledged that it previously dismissed all criminal charges against Baldwin because it believed it was possible that the gun was modified, and therefore that Baldwin did not pull the trigger. That's why they sent it to the FBI. By the way, they did that as a courtesy to the defense. The defense said, listen, can we for a variety of reasons, including many missteps by the first prosecution team, the defense asked Carrie Morrison, listen, the first prosecution team, they've resigned. You're in charge now. We haven't even tested the gun for the possibility of an unintentional discharge. While we do that, would you agree, without prejudice, without prejudice, to drop the first indictment? You're free to if it turns out the gun was operating fine, you're free to re-indict him. But so it's not hanging over our client's head. It's bad press for him. And Carrie Morrissey said, sure, as a professional courtesy, I'll do that for you. And now they're using it against her.
It's great. I will say that's nothing that really pisses off prosecutors, but you got to zealously advocate for your client. I think this motion is well written.
By the way, I think Carrie Morrissey did it because she is a defense attorney. So her whole career was as a defense attorney. She's only a prosecutor for this one case as a special prosecutor. So I think she got a request from opposing defense counsel and was thinking, well, what would I do? If I were defense, I'd make that request too. So sure, I'll go ahead and do that. I think a more hard-bitten career prosecutor might have said, nah, I think we'll just leave it the way it is.
That's great.
That alone demonstrates how critical this issue is to this prosecution and how severely Baldwin has been prejudiced by the state's destruction of the firearm. Put that in context. The state, by its conduct of dismissing the case, conceded that it would not bring this prosecution if Baldwin could prove the gun was modified. Yet the state's intentional and inexplicable actions have ensured that we can never know whether those defects were present on October 21st, 2021. By the way, I think if you ask the state, they would say, no, that's not what we were saying at all when we agreed to dismiss the first indictment. There were lots of reasons to dismiss the first indictment. We did it to clean the slate and start with a fresh slate.
Yeah, I noticed how there's no citation to that sentence.
Right.
So it just means we're
making it up.
This is what I'm saying. It happens.
We're doing some mind reading here.
Yeah. It's just like no cite. It's just rhetoric.
That is also why the state's claim that the defendant failed to present any evidence that the smoothed parts and file marks actually caused the revolver to discharge without a pull of the trigger is so cynical. The defense cannot marshal evidence that the defects actually caused the gun to fire because the state prevented the defense from examining or testing the firearm in its original state. But if the parts that prevent the gun from accidentally discharging were seriously defective at the time of the accident, that would almost certainly establish reasonable doubt of guilt. Reasonable doubt of guilt. And that is sufficient to meet the apparently exculpatory standard. So one thing I suspect that's happening here, when this goes to trial, I think we'll see this. So the parts of the hammer that matter for this purpose, whether the gun could be discharged without pulling the trigger, is limited to the notch on the curved interior of the hammer where the sear engages. That's it. Now, the hammer is shaped like the interior part is shaped, it's a curve, it's circular, so it has sides. And I could imagine that these tool marks are on the sides of the hammer. That would have nothing to do with whether or not the gun could discharge without the trigger being pressed. And I feel like the defense is obfuscating that, because I think if the tool marks were at the sear hammer engagement point, they'd be making that claim here, and they're not doing that.
Well, and can I just point out that I follow what you're saying, and I know something about firearms, but you're talking very technically and very firearm technically. And when I hear these arguments being made, like you're saying, there's no way this could happen, it kind of goes over. If I'm just an average juror that doesn't have firearms knowledge, that's just going to go right over my head. It's going to hear like blah, 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 blah. And so then the defense can put their nose under the tent and say, oh, you have doubts, don't you? Because the
Right.
people have ignorance. So I understand what they're doing here, and this is interesting. The apparently exculpatory standard. Do they have a circumstantial evidence rule type standard in New Mexico? And is this a purely circumstantial case that would meet that rule? I'm wondering what they're getting at with that.
Well, it's not purely circumstantial. I mean, we have eyewitness evidence,
But it's a
testimony,
negligence theory, right? It's a culpable
recklessness.
negligence theory. So if it's a culpable negligence theory, how do you prove culpable negligence? And is it by circumstance? I don't know.
Well,
That's
I would argue that you don't even need the trigger pull. I would argue that
yes,
there's more than one basis for recklessness, one of which is that the gun was pointed at a human being. What he knew to be a real gun was pointed at a human being, and that's incontestable because
right.
that's where
No,
the
I
bullets
agree
are.
with all of that, but I'm thinking from a defense standpoint, you're trying to look for what is your best defense here. You can't argue identity, you can't argue the person's not dead.
Right. Yep.
You know, you can say that those steps are not sufficient to meet a culpable negligence standard. And these are and maybe you're looking for a JOA, a judgment of acquittal at the close of all evidence. You can argue that it's a circumstantial case to prove culpable negligence, and therefore, because the state destroyed the thing that would I'm just thinking about a JOA argument, that what they're setting up here.
Yep. Yeah, I agree. I mean, to me, it's almost analogous to I mean, the classic reckless killing case is a drunk driving case, right? Someone gets drunk at a bar, gets behind the wheel to drive home. They're not intending to cause injury to anyone. They're just trying to get home.
Right.
But they know when they get behind the wheel drunk that they are engaged in reckless conduct, that they're creating an unjustified risk of death or serious bodily injury to other parties. And then if they run over Granny in the crosswalk while driving drunk, that's reckless homicide. That's reckless manslaughter. Now, if the police then take that car and say, you know what, we're going to test the brakes to make sure the brakes were not defective, and somehow they end up damaging the car, that doesn't mean you lose the case.
Right.
That just means that becomes a set of facts that the defense can argue.
That's a very good analogy, because you could say inherently driving any car in a state of inebriation in which that your faculties were reasonably affected, right? That is inherently dangerous. That is inherently culpably negligent and criminally negligent. So you could say the same thing here. Doesn't matter if the firearm is defective or not.
Right.
Taking the actions that he did, pointing a firearm that he does not
gun, right?
At a person, that is inherently negligent, such as driving a car. Even if, like, you're driving drunk, but nobody got hit and nobody got killed, but it's still negligent because of the possibility. And here he's taking actions such as getting in a car drunk. Right. He is instead pointing a gun at somebody, regardless of the defectiveness of the gun. So that's interesting. Yeah.
And I expect that, again, because this modification of the parts does get technical, I expect that Carrie Morrissey, I forget now, would she might end up in closing and say, listen, you heard all this evidence about the, maybe modification of the gun. I don't think that explains anything, but maybe you do. That's fine. You're the jury. You get to decide. It doesn't matter, because he was still reckless the moment he pointed that muzzle at her. That's enough. Let's see. The state's other points are irrelevant, the defense says, of course. For example, the state says that Baldwin admitted that the gun worked without issue on the days before October 21st and properly test fired in later testing. But a defective gun does not constantly misfire. Otherwise, all defects would be identified immediately. The government also asserts that at least one witness observed his finger on the trigger during the accident, without identifying the witness. But that is exactly the point. The government plans to present a case that relies on the claim that Baldwin pulled the trigger, but it intentionally deprived the defense of the evidence that could refute that allegation. In fact, the state's already argued that there's multiple grounds for recklessness here. It has done so without any explanation whatsoever for why investigators did not at least document the internal condition of the firearm before destroying it. This is not a case of mere speculation or conjecture, and the cases cited by the state on that point all involve facts and circumstances far afield from those before this court. So they're just distinguishing the state citations here. I'll skip over that because none of us have read these cases. Here, the potential exculpatory value was not only obvious from the statements by Baldwin and others, it was overtly acknowledged by the state as the very reason to conduct further testing.
But see, that contradicts their intentional, like, why did they do that? They had this is the bad faith, good faith argument, because the state can say we are absolutely operating good faith because of this very statement,
right?
Because we're trying to rebut your theory of guilt, right? Or your theory of innocence. So that is a good faith reason for the additional testing.
And that value continues to be apparent today. The state's experts remain unable to explain file marks indicative of potential modification on the trigger, but have concluded that the FBI testing likely did not cause it. A finding they made in August of 2023, but that was only disclosed to the defense in the last weeks. The firearm's exculpatory value was therefore apparent before the state destroyed it without documenting its internal condition. 2, comparable evidence is not reasonably available. The defense does not have any evidence available that is comparable to the original unaltered firearm. That means both that the defense cannot conduct its own test on the firearm and that the defense cannot adequately respond to the state's claim that the FBI testing caused the modifications to the hammer and the sear. And again, I think that the defense here is really conflating different things, because sometimes they talk about machine marks and file marks. Where was that? Here, they talk about file marks indicative of a potential. But what the FBI is saying they broke is not file marks. They broke a metal component of the hammer and the sear. That's not a file mark. That's a fracture of the metal. So the FBI is saying, yeah, no, we broke the tip of the sear off the trigger for sure when we did the mallet test. That's got nothing to do with any file marks anywhere on the gun. That satisfies the second factor under Trombetta through the state's own actions, both its destruction of the gun and the failure to first document its internal condition. The state has prevented the defense from accessing this critical evidence. The state asserts that the FBI's testing and the state's experts' testimony provide an adequate substitute for the original firearm, but that is non-responsive to the problem that the state's actions created. The defense should not be required to blindly trust the state's paid experts, who, in any event, did not examine the internal components of the firearm in its original state. By the way, the defense very frequently relies only on the state's expert. I mean, most criminal defendants are not hiring their own experts. They don't have any money to hire experts to do these kinds of evaluations. When the state does drug testing or DNA testing, it's not that common for the defense to replicate that with its own drug testing and its own DNA testing. In fairness, because the defense knows if they test the drugs, it'll probably come back positive. And there's no evidence to substantiate the state's implausible claim that striking the gun with a mallet somehow smoothed out the hammer and the sear. Well, that's just a factual dispute that could be argued at trial by the experts. In fact, the FBI's testing did not make any effort to replicate the circumstances under which the revolver fired, because state investigators did not inform the FBI about those circumstances. Well, that's not true. First of all, how the circumstances under which the revolver fired is in dispute, right? The state is saying it fired because the trigger was pressed, and the defense is saying it was fired without the trigger being pressed. The FBI did both those things. They tried to get the hammer to drop without pressing the trigger, and they dropped the hammer pressing the trigger. So I don't know what they didn't replicate. No communications regarding the circumstances of the firing of the gun were ever included on any log, nor could any witness interviewed recall such communications. While the state's experts have described a different test that would have been appropriate and would not have resulted in damage, the push-off test, that is not the test the state elected to carry out. Do you know what the push-off test is, Steve?
I do not. You know, this is I am a little. I will say that, giving the defense some due, this testing that destroys the gun is an odd thing. I've never really seen a gun destroyed in testing. This hammer test. Now, it's possible maybe I'm a little out of date, and That's very possible because I've been doing appeals, and this is more of a trial type issue. But that to me bothers me. It does bother me, and I get where the defense is coming from. I think they're taking it way too far, and they're assuming a lot of stuff. There's a lot of uncited things. I think they could trim this motion down quite a bit and maybe have some effect. Otherwise, they're just rehearsing their jury arguments.
So I just did a quick search. It looks like the push-off test is simply where you cock the hammer and then you try to press the hammer forward with your thumb.
Yeah, well, I really, in jumping ahead a little bit, there needs to be an evidentiary hearing here. And a lot of these questions need, what is the state of the firearm now? What was done? What was documented? What procedures were followed by the FBI? Have the FBI come in and testify in an evidentiary hearing? And let's get these, because there's a lot of allegations flying back and forth and questions that need to be resolved. But, looking through the tea leaves here, it looks to me like a practice run at a jury argument.
Yeah. And of course, a lot of these questions were addressed. I mean, what was the testing that was done was testified to by the FBI examiner who did the testing in the Halyna Hutchins trial, which was presided over by this same judge. So she's heard that explanation. But yeah, I hope they do have an evidentiary hearing. That'll be fun to cover.
That would be fun to cover, actually.
Moreover, recent untimely disclosures from the state have revealed that the hammer and the sear do have unexplained modification or damage not apparently attributable to original manufacture or the FBI's testing.
See, now here's an example of editing. As a defense attorney, this comes across to me like whining, because it was disclosed weeks ago. Do you have a motion for sanctions? Do you have this? Was there material prejudice? It was disclosed. Okay, now maybe it wasn't at the time, but this is just whining. Recent untimely disclosures from the state. It's very vague and it's just whining. You could delete that. You don't need. But what are you trying to prove by that? You're just whining, right? Do you understand that?
Yeah, and there's a lot of that in these defense motions. A lot of castigation of the state, a lot of they're bad people, they're acting in bad faith, they're doing bad things. And of course, if you're the defense, the state is trying to put your client in prison for as long as they possibly can. But there's so much histrionic language, so much emotionally driven. And especially if you know this judge. I mean, this judge is almost in a coma sometimes. I mean, she's very, unemotional. In everything she does. She's very low key. She's not like a Judge, Schroeder, for example, who's much more emotive, or at least was much more emotive.
But the problem is that if you do have a real disclosure issue, you've muddied the waters by complaining so much about stuff that doesn't get you anything. This wine doesn't get you anywhere. It doesn't make a difference. So leave it out and keep your powder dry for a time when it might make a difference.
Let's see. The report was not known to Baldwin or disclosed by the state until Mr. Haig's son, Michael Haig, alluded to it during a pretrial interview conducted May 21st. Special Prosecutor Morrissey's only explanation for why the state did not disclose the report sooner is that she intended to forward it for disclosure the day it was received, but for some unexplained reason, editing here, that she can see from her email that she did not. Notwithstanding the report's exculpatory conclusions, the state's experts maintain that it is impossible to determine today whether and to what extent that damage contributed to the malfunction of the firearm on October 21st. Put simply, because of the state's deliberate decision to conduct destructive testing on the firearm without documenting its internal condition, there is not a single witness who can offer comparable evidence or any evidence at all as to the condition of the firearm's internal components on the date of the accident. So again, go back to my drunk driving analogy, right? So the person gets drunk, they get behind the wheel, they run over Granny in the crosswalk, and immediately afterwards, they drive the car off a cliff and miraculously survive to be prosecuted, but the car is utterly destroyed in the crash off the cliff. Does that mean you can't prosecute them for the vehicular homicide? I would think not. Unsurprisingly, courts have not allowed the prosecution to escape the requirements of Trombetta when investigators had an opportunity to document the evidence before destroying it, but failed to do so. I'm going to skip over this because I think these will be distinguishable cases where it's not a matter of, for example, disassembling a gun and looking at all the internal components before you otherwise do testing.
You have a footnote of a whining footnote.
Let's see. The August 31st Hague report is not the only exculpatory evidence relevant to this motion that the state failed to disclose in a timely manner. For example, on May 6th, the state disclosed email communications between the state and Brian Carpenter. That was the state's expert armorer witness in the Halyna Hutchins trial, and he'll be called for that purpose in this trial too, who, although not qualified as a firearms expert, does have a military background, in which Special Prosecutor Morrissey noted the stark difference between the hammer notches on the gun Baldwin was given on the set of Rust and the notches that appear on a brand new hammer from the exact same gun. Well, this shouldn't surprise anyone, because a brand new gun would not be subject to a mallet test and have the sear broken off, which is what happened after the shooting with the Baldwin test. In response, Carpenter stated that he cannot see any reason that's functionally necessary or does not compromise the safety, integrity, and or I don't even understand. In response, stated he cannot see any reason that's functionally necessary or does not compromise the safety, integrity, and or operation of the gun. That's just an incomplete sentence, isn't it?
This is just more whining to me. They footnoted some whining. You really got to focus. Discipline, lawyers.
Yeah. Okay. So let's see. Grasping at straws. The state argues that Baldwin can question one of the state's paid experts who tested the gun using replacement parts, in particular, a new sear. Yeah, this is my recollection from the Gutierrez trial. In other words, to determine whether the gun's defective parts cause an accidental discharge, the state replaced one of those parts. Obviously, this says nothing about whether the firearm could have gone off with the original parts, except when the gun was examined prior to the mallet test with the original parts, it functioned in the same manner as it did with the replacement parts. And this is a very simple mechanism, folks. External function reflects the state of the internal components. Although the state's expert used the original hammer, it is the interaction of the hammer with the sear that prevents a properly functioning firearm from discharging. Without using the original sear, that testing showed nothing. Moreover, the expert admitted that it was not possible to test the firearm with the original parts, and in particular with the original trigger, the same part that bears unidentified modifications, because the damage done to the trigger was such that it would not be possible to replicate the functioning of the firearm. Yeah, well, the tip was broken off, so the original trigger is no good. The young blood standard is met. The distinct alternative young blood standard is also satisfied because the record contains overwhelming evidence of the government's bad faith.
See, this is a real stretch, because they admit in other parts of the motion that the state was having this testing done to rebut defense allegations that he didn't pull the trigger. So that is a good faith argument on the part of the government. So, but
they even say that's why the original indictment was dismissed by the prosecution. They were willing to wait for these test results.
But let's see what they have to say about the young blood standard.
So, one, the original state of the firearm was at minimum potentially useful. As set forth above, if the firearm was not apparently exculpatory, and it was certainly potentially useful, which requires no more than a possibility that the evidence would have exonerated the defendant. Other than a single conclusory assertion, the state makes no argument that the firearm in its original state was not at least potentially useful to the defense. Two, the evidence of the state's bad faith is overwhelming.
I guess it's histrionic language.
It is hard. It sounds like Trump wrote this sometimes, right? It's like the most fantastic, the most amazing bad faith you've ever seen.
Most striking
bad faith. It is hard to find a more striking precedent of governmental bad faith leading to the destruction of potentially exculpatory evidence.
I've seen a lot where this is not even on the charts.
Both prosecutors and law enforcement agents knew months before testing that Baldwin claimed he did not pull the trigger and that other witnesses had said the gun just went off. They knew the testing would destroy the gun. I don't believe they knew that. And as the state's own experts have confirmed, the testing that the sheriff's office ordered was not tailored to determining whether the firearm could have discharged without the pull of the trigger. Yet the state failed to document the original condition of the firearm's internal components through photographs or video, even though it would have been simple to do so before they destroyed the gun. The state also failed to alert Baldwin or his attorney about what they were about to do. The state thus took no reasonable steps to preserve potentially, indeed apparently, exculpatory evidence for the defense because prosecutors and agents were convinced Baldwin was guilty and gave no consideration to Baldwin's right to put on a defense. The bad faith is palpable.
Yeah, that's histrionic. That's just dramatic writing. I'm wondering who's the audience here? Who's the audience for this motion?
Yeah, I can't believe it. Well, so one theory I have, Steve, is that the real purpose of the defense here is not an acquittal, which of course they'll take if they can get. But what they're doing is establishing a foundation for reputation rehabilitation after the conviction. So they want to be able to show, sure, 5 years from now, yeah, Alec Baldwin, he was convicted, but that was a kangaroo court. I mean, we made tons of arguments to that judge that she just disregarded. And that's what led to this unjust conviction. This was a travesty of justice. Look at all these motions we filed. Look at all these arguments we made, and the judge just disregarded them. If they don't do any of this, they don't have that to point at, right? Tellingly, the state's brief does not even address FBI Special Agent Cortez's statement that he and Detective Hancock were tracking that the requested testing will alter the firearm and it will no longer be in the same physical condition that it was seized in. Nor does the state offer any explanation whatsoever for why these law enforcement agents and others who were aware of the imminent destruction did not first disassemble the firearm and document its internal components for the defense. The state's silence speaks volumes. It has no legitimate justification for its staggering disregard of Baldwin's rights. I don't even know what this means. We're tracking that the requested testing will alter the firearm and it will no longer be in the same physical condition that it was seized in. Well, the moment you fire a round down the gun, you've altered the firearm. It's not the same as it was before you fired that round. That doesn't mean they knew they were destroying the gun. The state argues that there was no bad faith because the FBI supposedly followed standard operating procedures when carrying out the testing. The state cites the 10th Circuit's decision in Bohl for the proposition that courts have held that the government does not necessarily engage in bad faith conduct when the destruction of evidence results from a standard procedure employed by the government, department, or agency regarding the disposal of like evidence. At least then there is adequate documentation of the destroyed evidence. But this passage from Bohl addresses the disposal of like evidence and presumed adequate documentation of the destroyed evidence. Here, however, the state did not create adequate documentation. Well, adequate's doing a lot of heavy lifting here, folks. Adequate documentation of the destroyed evidence, such as by photographing the internal components of the firearm. That is the problem. Moreover, unlike in Bohl, the firearm was not destroyed as part of a disposal process. The damage it suffered was an anticipated consequence of testing that should never have been performed. But at any rate, regardless of the applicability of Bohl to the FBI's testing, that is not where the bad faith lies in this case. So why do we talk about it? Rather, as each and every FBI witness in this case has confirmed under the FBI laboratory procedures, what testing to conduct is a decision that rests with the contributor. Here, lead Santa Fe Sheriff's Office Detective Alexandria Hancock. It was Detective Hancock, not the FBI, who set out to disprove Baldwin's statement. I don't understand why they keep talking about that. The state's allowed to do that. It was Detective Hancock, not the FBI, who failed to provide information about the relevant circumstances of the incident and who requested testing that she knew would likely destroy the firearm. Likely, it was Detective Hancock, not the FBI, who decided not to request photos, videos, or other information about the internal condition of the firearm before its destruction. And it was Detective Hancock who declined to inform the targets of the investigation that she was planning to destroy a piece of evidence at the center of this case. I don't believe she was ever planning to destroy anything. Were it not for each of these deliberate decisions, the firearm or documentation of its internal components would have been available to the defense today. The state's efforts to hide behind the FBI's standard procedures should be rejected. The state also discusses 5 factors that the 10th Circuit has employed to conduct the bad faith inquiry, but those factors weigh heavily in favor of bad faith here. First, Detective Hancock was clearly on notice of the firearm's evidentiary value. As she said, the testing was done to disprove Baldwin's statement that the firearm went off. There can be no doubt that the state was on notice that the defense viewed the firearm as exculpatory. The state's argument that Baldwin didn't specifically say the gun malfunctioned is not serious. Explaining that the gun discharged without the trigger being pulled is the same thing as stating that it malfunctioned. And of course, Baldwin, an actor, not a gun expert, had no idea whether the gun had been altered and was malfunctioning prior to the day of the shooting. All he knew was that it went off without his pulling the trigger, he says. And he repeatedly told investigators that months before the destructive testing. So they should just take the defendant's word for it. Second, it is clear from the third and untimely disclosed Hague report that the firearm does have markings indicating modifications not attributable to the FBI's testing. The state claims that Baldwin does not present any objective evidence to substantiate his bold claims that the gun was altered and modified prior to the accident, but the state's own evidence makes that clear. Third, this government has had control of the firearm from October 21st, the day of the shooting, through today, and was in possession of it when Baldwin disclaimed pulling the trigger. And it was the sheriff's office, not the FBI, that ordered the testing. Okay, why would the FBI be involved but for that request? Fourth, the centrality of the firearm to this case could not be more obvious. It was clear when Detective Hancock set out to disprove Baldwin's statements by requesting the destructive testing. It was clear when the state dismissed the case last year based on its belief that the firearm may have been modified. And it remains clear today, given that the state's witness list includes 2 firearms experts, the manufacturer of the firearm and the importer of the firearm, all of whom are expected to testify about the firearm, though none of whom observed the firearm as it was on October 21st. Fifth, the state has not offered any explanation for Detective Hancock's decision to authorize destructive testing untethered to the circumstances of the case, with no notice to the targets, including the target whose statements she had set out to disprove. Finally, the state misstates the legal standard. The state says, for example, that the FBI testing was not conducted to destroy exculpatory or potentially exculpatory evidence, and that Baldwin cannot show that officers damaged the firearm for the sole purpose of depriving defendant of exculpatory evidence. But Youngblood does not require that the sole purpose of the testing was to destroy the evidence. Rather, bad faith turns on whether the government knew the evidence was potentially exculpatory and then destroyed it without reasonable steps to document or preserve a record of the evidence. Again, reasonable steps is doing a lot of heavy lifting here, folks. The state cited legal authority is equally unavailing. They mentioned, I'm going to skip over much of this because we didn't read those cases. It bears noting the state's efforts to deprive Baldwin of relevant and exculpatory evidence related to the firearm has continued. The state's brief ignores what Hague revealed to the defense, that even after taking into account the FBI's testing, the state's own experts can explain markings and indicia of modification of the trigger. That is the kind of confirmatory evidence the state pretends does not exist. The state's unjustifiable decision to destroy the firearm without documenting its internal components means that the defense cannot definitively establish how the internal components interacted in their original state and whether they caused the accidental discharge. 3, the prosecution also violates New Mexico law. The prosecution also violates New Mexico law as recognized by State v. Chouinard, a New Mexico Supreme Court decision. The New Mexico's Constitution guarantee of due process provides even more robust protections than its federal counterpart for defendants in criminal cases where exculpatory evidence has been destroyed. For all the above reasons, the firearm's original condition is material. The state's theory of guilt would be refuted if the firearm could discharge without a pull of the trigger. That's not true. There's other grounds for recklessness here. And for example, my drunk driving scenario. Imagine if the drunk driver had not only consumed alcohol, but also hallucinogenics. They were having that kind of a weekend, both of which cause them to be impaired while driving. And they run over that old lady in the crosswalk and kill her. They're charged with vehicular manslaughter. And it turns out that the claim that she'd consumed alcohol was demonstrably untrue. The alcohol goes away. Does that loss of that one theory of impairment mean it's not vehicular homicide? Not if there's another theory of impairment. So the state has other theories of guilt besides the pull of the trigger, simply pointing the muzzle at Halyna Hutchins. And the destruction of the firearm prejudiced Baldwin because the defense can no longer contest or examine the firearm in that original state.
What is the what are there's the rules? What are the
4 rules of gun safety?
4 rules of gun safety, right?
All guns are presumed loaded until you confirm otherwise. Never point a gun at anything you're not willing to destroy. Never press the trigger unless you want to hear a loud noise. Know your target and what is behind your target.
So 3 of the 4 were violated. So the only question is one of those 4 elements. So if there's culpable negligence by violating 3 of the 4 rules, assuming he didn't pull the trigger, which is a stretch.
Right. And he's not being prosecuted for like reckless endangerment or a battery on Joel Souza. I guess battery wouldn't apply because no one believes he intentionally fired the gun. But reckless endangerment, I mean, the bullet hit Joel Souza. That would be an example of not knowing what was behind your target, I guess.
Right.
In addition, the state acted in bad faith by intentionally destroying the firearm without documenting its original condition and by violating its evidence preservation obligations under Brady. Brady is the U.S. Supreme Court case that has to do with preservation and discovery of evidence in criminal cases, and New Mexico law, an argument the state fails to address. The state's characterization of the destruction as accidental is inaccurate. Investigators knew the testing would destroy the gun and acknowledged that fact in writing. I don't believe that's a true statement. I believe the state was aware or had been noticed that testing could destroy the gun. And in any event, the accidental destruction of material evidence can lead to severe remedies under New Mexico law. Well, that may be true, but that doesn't mean the remedy must include dismissal of the indictment with prejudice.
I'll see. Look at this. This is interesting. It's the state's other responses. This is what I was asking because, see, yeah, go ahead and read that. That's interesting.
The state's other responses also obscure the record. The state says, for example, that, quote, law enforcement carefully documented and recorded the revolver's condition pre-test by photographing it, examining it, and test firing it, close quote. No, they did not. They failed to disassemble the weapon and photograph its internal parts, steps that would have determined whether the gun was defective or altered on the day of the accident.
You see, this is that's interesting because they're making large, broad, categorical statements throughout this motion. They did no testing at all. They just threw it away. They just say, they're making these big things. But now it appears that there was quite a bit of documentation. They just didn't do it to the precision or the way that the defense wanted it, which was to disassemble and look at every part and put it through an X-ray machine.
Right. When they say no, they did not, really the only operative word they're targeting with that phrase is the word carefully. Because if the state said, well, we documented and recorded the revolver's condition, that's indisputable. Now, whether or not they did it.
I mean, to me, you could still is photographing, examining, and test firing it. That could be carefully documenting.
That's my point, right? The state believes that's careful. All the defense is saying is it wasn't careful.
Well, they're saying that they should have done more. Right. Which is always an argument, but this contradicts all of the earlier broad statements which they were criticizing the state for. They would make these broad, sweeping characterizations. They did nothing to document. It's been completely destroyed, and we have no way of all these big, broad statements. When in fact, it looks to me like, this is why I was surprised because I'm reading it and I'm like, really? They didn't photograph it? They didn't test fire it? They didn't do any of these things? They didn't do trigger pull measurements? They probably did all of those things.
They did all of that.
What they didn't do is they didn't disassemble every little piece in an exploded fashion and then, But then, like you said, if they had done that, then it's like, well, now you altered the weapon.
And it still wouldn't be enough, because then they'd say, well, you didn't send each component to Lawrence Livermore Lab for atomic microscopy examination, right? There's always something you don't do.
Right. So this is it. That was just, here it is on page 18 and it's buried. But I mean, that's why I was surprised, because I'm like, the state didn't do that, really? And now, of course, they did. And now it's just a matter of extent. Yeah.
The state also says that Baldwin has not presented any objective evidence to show the gun was modified or altered prior to October 21st. Wrong again. The state's own expert. Why do you need wrong again, right? That's just being trite.
Yeah.
They could just have gone with the next sentence. The state's own expert has now confirmed that the visible alterations in the hammer are not attributable, and sear are not attributable to the FBI testing. To be sure, Baldwin will never be able to establish that all of the defects and modifications of the parts. Well, this is an incomplete sentence.
Well, here's another thing about these the modifications and defects. That's a general, broad statement.
It's just a claim.
It's just a claim, but it's like, well, what are we talking about? Are we talking about maybe a polishing of the hammer? Sometimes you might have a spur, or you might have something to make it smooth. So you get somebody with a Dremel tool that polishes it. Now that's a defect and a modification. It's just a general, it was altered, inexplicably tainted, right? But it's like, well, what are we talking about? We're talking about a Dremel tool polishing a side to slide, to make it slide better, or, make the revolver work better.
Right.
That is, to say there was a defect, it's unobjected that's what happened. And then to extrapolate that is somehow some kind of nefarious defect. They're hiding behind vague language.
Let's see. And the state cannot seriously, to be sure, Baldwin will never be able to establish that all of the defects and modifications to the parts pre-existed the FBI's testing, but that is because the state destroyed the gun without first documenting its internal condition. And the state cannot seriously dispute that whether the gun was functioning properly is central to the issues in this case. That is why, after all, the state sought to test the testing in the first place. Well, first of all, not everything that's tested is central to the issues in the case. Finally, the state says that none of its conduct amounts to a legal violation because Baldwin can cross-examine the FBI examiner, the state's firearms expert, and Detective Hancock. As explained above, these examinations have no chance of revealing the original state of the firearm because none of those witnesses examined the internal components of the firearm before destroying it. The state has no answer to that problem.
Well, I don't know about that either, but let's see. We'll keep going.
Well, we can make reasonable inferences. I mean, in no shooting that I've ever seen was the gun carefully examined prior to the shooting. No one disassembled the gun, examined all the parts for defects, put it back together, and then committed the shooting. That's not a thing that happens.
I like Kyle. Kyle says, like I wrote to Will, it's what, Schrodinger's gun? That's good.
Right. Either you take it apart, you don't take it apart. It's always the wrong answer.
Right. It's like, oh, was it behind that mystery box? Something happened. And whatever, when you look at it, all of a sudden that determines, right, whichever way it is.
So for the foregoing reasons, Baldwin requests the court to dismiss this action with prejudice or preclude evidence or argument from the prosecution regarding whether Baldwin pulled the trigger and instruct the jury that he did not do so. The judge is supposed to instruct the jury. I'm telling you, as a matter of fact and law, that Alec Baldwin did not press the trigger of this gun.
Yeah, and does they have local counsel?
I think that kind of overreach is harmful. I think if I were the judge and I read that, I'm like, I'd be thinking, you know what? I'm pretty sure I'm the judge.
Yeah,
and they're the jury.
Like I said, when I read this reads to me like it has an audience of somebody other than the judge. I think there's a lot of fat in here. I would trim a lot of this fat off this motion if I were them. But I'm not really involved in their defense, and I don't see why they're being the way they are. I think there's a lot of unnecessary language. It's almost like they know they're going to lose this. But I don't know. See, I think there's a legitimate complaint here on the part. They could maybe get a favorable instruction. I think they might be able to get something out of this because the destruction of the gun or the destruction of hammering it with a hammer does seem to me to be problematic from a defense standpoint. And if you kept it real tight and narrow and not as boisterous, you might actually get some kind of remedy. But this kind of boisterous language loses credibility on the good points. That would be my, but I don't know who their audience is. You know, they may be arguing for their client. Their client might want this, or
I think
like
their
you said,
audience is actually, again, I think this
the
is all about
reputation.
building a foundation for reputation rehabilitation. So like journalists will have language they can cherry pick from these
Right,
motions afterwards, right?
right.
Court documents even said that blah, 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 right?
Yeah,
These are
and they're
court
gonna,
documents, right?
yes, that's right. Oh, yeah, that's, you know, the media could be their audience, but this is gonna be a New Mexico jury, and I'd worry about the criminal case in New Mexico and the sentencing before I would worry about media image. But
So I'm not going to go over this, folks. This is like an addendum. This is all different combined exhibits, 36 pages of exhibits. It's expert reports. It's other stuff that the defense wants the judge to consider. If you're a law self-defense member, I will include this PDF in the replay version of today's show, the blog version, the blog post version of today's show. So you'll have access. Oh, there's the revolver, the hammer at various positions.
so look, it's pretty
I
well
wonder if they have
documented.
photos here of the hammer. I bet they do. Let me just scroll through real quick.
I think it was up top there. That was that exhibit, but let's. So you'll post this
Okay.
entire document.
I'll go
I
back.
think it was on that first photograph that she skipped through there. Keep going there. Yeah, there it is.
Yeah, so that's the very tip of that's the end of the hammer, of the trigger rather, that we can't see. So we see the trigger, we press with our finger. There's a pivot right there at the top of what we see, and then inside the gun is the sear. It looks like a reverse of the trigger almost. It's got a tip, and the tip engages with a notch in the hammer. That's how the gun operates, and we can see from afterwards, after the mallet testing, this little lip appears to have been broken off. I'm not sure what we're looking at there, where it's broken off. Yeah.
Looks pretty well documented to me.
Well, this is after it broke, though.
Right. Okay.
Right? So the defense wants to be able to argue that for all we know, this is what it looked like before it broke. I would suggest we know it didn't look like this before it broke, because when it looks like this, the hammer can't be held back unless you physically do so, but it can't be held back by the trigger. But prior to the mallet test, the gun was tested, and the hammer was being held back by the trigger. So I think the only reasonable inference is that the sear was intact when the gun was received by the FBI and initially tested. It was only the mallet test that broke the tip off the sear.
Yeah, as a threshold defense attorney objection, I don't like this hammer test thing. Whatever they're doing with it, it annoys me. But what do I know?
All right. So, Steve, you got anything coming up? You got any new books?
I do. I've got my new book called Death Penalty Designs, Maximum Due Process, which I'm probably going to have out on it's going to be released on June 21st. So if people know my other books, Death Penalty Desires, Death Penalty Debates, this is the third book in that series. So the way it is that the fictional novel kind of gives you a framework for understanding how a crime occurs, an investigation, a trial, and then the aftermath in a death penalty case. Death Penalty Debates is the public policy arguments on both sides surrounding the death penalty. This is a resolution of since I'm leaving the public defender's office, this is all the work that I've done training myself to be a capital appellate lawyer. So it starts with an overview of the death penalty in history. It then goes into an overview of federal case law having to do with the death penalty, organized by topic. Then it is an analysis. Then it is a presentation of Florida's death penalty statute and how the death penalty statute works. And then the fifth part is an overall, basically a step-by-step, all the constitutional problems with Florida's death penalty from an appellate standpoint. So all the taking and applying those federal cases to the Florida statute. So it's a kind of an advanced book, like Ideas and Answers of Law, which Mr. Branca here, Happy, did the intro. It is it's a heavy law book, and so it's going to be priced high. But this is kind of my end masterwork that I can put the death penalty behind me, and I can move on to the state attorney's office, which I have said that I am not doing death penalty cases for the state, and nor will I assist in that based on religious objections. And they've agreed to that. And so that made me happy. But this will give you, if people are hard law, kind of people like law geeks, like a lot of your law self-defense community, it will be available at least through June 26th. It's kind of, I wanted to put it out because it's so much work that I put into this. It was designed to be a training manual for capital appellate lawyers, but it's just not going to get completely finished exactly what I wanted. But before I walked away from it, I wanted to put it out and make it available to capital practitioners. So that's what's going on. So I might have a release party on Thursday or some thereabouts, and it is available for pre-order. So if you're a real law nerd, which you've got a lot of them. I mean, we've done the American law cases. We've even talked a little bit about maybe following up with this type of information. But anyways,
hey Steve, can you spend a few more minutes with us for the Q&A portion?
Oh yeah, I'd love
that.
to.
That'll just be for the law of self-defense members. So just to remind everybody, when we do the Q&A and comment portions here, it's only for law of self-defense members. If you're watching this on YouTube or on Rumble or on X, the show is ending for you in the next few minutes. If you're a law of self-defense member watching this in the live stream, don't go anywhere. We're going to be back in just 20 seconds as I shut down the other streams, and we'll address all the questions and comments in the live chat. The good news is it's dirt cheap to be a law of self-defense member. You can try it out for 2 weeks for just 99 cents for a 2-week trial at lawofselfdefense.com/trial. And after the 2 weeks, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a law of self-defense member. Lots of benefits. You get transcripts of every show, so you can document your specialized knowledge if you, heaven forbid, ever have to defend your use of force in court. And you get to participate in the Q&A comment section as well. So check it out at lawofselfdefense.com/trial. If it's not for you, you can always cancel, folks. No questions asked. We'll refund your money. All right. So with Twitter or I guess I should say X, YouTube, and Rumble, the show is ending for you now. I'll just remind all of you in the general audience, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Again, members, don't go anywhere. We'll be back in 20 seconds. Everybody else, I'll see you at the next Law of Self-Defense show, probably tomorrow.